This is SJC-13228, Veronica Archer v. Grubhub, Inc.
Great. Okay, Attorney Evangelos?
May it please the court, Theana Evangelos on behalf of Grubhub. I'm joined by my colleagues Blaine Evanson and Joshua Wisniewski. The Superior Court's decision below on Section 1 of the FAA is inconsistent with the rulings of courts in the Commonwealth and across the country. If this court were to affirm, it would create a direct conflict with the 1st, 7th, 9th, and 11th Circuit Courts of Appeals, all of which have held that local delivery of goods or passengers that previously traveled in interstate commerce do not fall within Section 1 of the FAA.
Let me ask you. Let's assume that Wallace is right and the United States District Court for the District of Massachusetts cases is right as it relates to these prepared meals, and that the customer that we have in mind for the ingredients is the restaurant. Assume that's right. What about the prepackaged from the convenience stores? What about those cases that talk about the last mile travelers as it relates to the prepackaged goods? Just put the restaurants aside for the moment.
Thank you, Justice Lowy. So the result is exactly the same, because this is not last mile delivery of goods. And in Wallace versus Grubhub, it involved exactly the same class of workers. And then Judge Amy Coney Barrett explained that the central job description of Grubhub drivers was not to move goods across state lines. That's exactly the situation here. And the last mile cases are totally different. They're worlds away from what we have here, because those involve a continuous stream of interstate commerce, whereby the goods are procured from out of state to the end consumer in one continuous transaction. Here, we have goods that may have ended up at a local restaurant or a store. They came from out of state potentially, but they reached their intended recipient when they got to the restaurant or they got to the store. It doesn't matter if it's a pizza made from the tomato sauce that came from Italy. It doesn't matter if it's a packaged good from a convenience store. All of those things are at rest. And exactly.
Well, I understand and appreciate your argument about the ingredients and the restaurants, and also that Walling versus Jackson paper is not an FAA case. But nonetheless, going back to the convenience stores and the prepackaged goods, why isn't the end customer there that is contemplated the customer who is having that last step of the delivery to his or her home?
Because the intended final recipient, we have to ask, when the good leaves its place, its home in out of state somewhere, where is it intended to end up? What's the end of that transaction? The end of that transaction is the local store. So that's the end of that journey. And then a subsequent separate journey might happen, and nobody knows what that is at that point. And the cases involving the FLSA, the other statutes that plaintiffs have relied on, like Walling, actually prove my point, because in Walling, if you recall, there were two separate fact patterns at issue. One was a special order that was brought in from out of state for the local consumer or local customer, and that was considered to be in interstate commerce. But goods that were delivered to the distributor and held in local stock for some later sale or later transaction, those were not in interstate commerce. And the Higgins case that was decided the same day by the Supreme Court made that same distinction. And this is, again, the courts that have found that last mile delivery does fall within Section 1. And I think, there's serious question about whether that's correct, but it doesn't matter for our purposes because we're so far removed from that. But those courts have also found that local transportation that's divorced from an interstate trip does not fall within Section 1. So the First Circuit in Wythaka said Amazon Flex drivers, yes, falls within section 1, but in Cunningham said that Lyft does not fall within section 1, even though in that case, I think there was an enormous percentage of passengers who were being picked up at Logan Airport. They came from out of state likely, and it didn't matter because as the US Supreme Court said in Yellow Cab, that is the sort of trip that is local. It is not in interstate commerce. And again, the Ninth Circuit in Rittman went one way on last mile delivery, but then in Grice and Capriol went the other for local transportation. And it specifically called out Postmates and DoorDash, who are exactly similar to what we have here. And in both Capriol and Rittman, and the court said, well, of course, local delivery is different and doesn't.
Are there any cases by any court that besides the Superior Court here that have found this kind of restaurant delivery workers covered, that they're interstate transportation workers? Are we a total outlier in the country?
Yes, Your Honor. This decision isn't a total outlier, and actually courts in the federal district court in Massachusetts has said that.
I saw Justice Tawani decided the other way. So, but again, is there any cases out there where Grubhub or restaurant people have been found this way? Because I mean, I understand they pick up a mustard or a ketchup and include it. I mean, that really can't be what we're talking about, can it? I mean, you got a sealed mustard and ketchup.
That's exactly right, Your Honor. There is no other case that I'm aware of. Every single case has come out the other way. This decision is an outlier.
Do you think the reason for that is because it focuses on the goods as opposed to what the employee is doing?
I think that is the error in the decision, exactly. And as Wallace explains, you have to look at what the worker is doing in the text of section 1, and Hamrick from the 11th Circuit explains this very concisely. The text of section 1 focuses on the worker being engaged in foreign or interstate commerce. It doesn't talk about where the good has been. So I think that is where the court
but the Amazon cases, and that's an overread, because the Amazon cases, those guys, you know, they deliver within their local community, but they're part of a, you know, sort of a flow that goes across the country that's different. I mean, but I just see these food service people, their primary responsibility is moving it from one local spot to another. And the goods are not, sort of going across the country the way the Amazon goods are, but it just, yeah.
Exactly. This is not part of a continuous stream of interstate commerce. There's no continuity of movement. This decision is a total outlier for that reason, because, and again, this is such an expansive view. It runs headlong into what the Supreme Court told us in Circuit City not to do. It would sweep in all sorts of local delivery, and the court in Wallace explained that. And and I think the fact that there's a prepackaged mustard or napkins or forks, or even prepackaged sodas or other goods. And there's another case from the Northern District of Illinois, Young versus Shipped, which dealt with deliveries from local stores. It wasn't just food items, but it was local stores. And that's the same as Hamrick from the 11th Circuit. So it doesn't matter really whether this is a prepackaged good or whether it's a passenger. And I think the passenger cases, Yellow Cab is exactly on point, and courts across the country have uniformly agreed that even where the passenger came from and is at an airport, I don't think there's, that's clearly someone who probably came from out of state. Doesn't matter, because this is a totally separate transaction. And when the good came into the state, it wasn't intended for that end customer who ordered it through the Grubhub app. It was intended for the store or the restaurant. And again,
right. And that point, counsel, sorry to interrupt you, that point is important to your definition of why the continuity has been interrupted. right? The person who or entity that has ordered the good interstate has received the good. And we don't know, that, Justice Wendlandt is now ordering a bag of potato chips in her home in Massachusetts from a Massachusetts entity. At the time it's ordered for its interstate journey, that journey ends at the 7-Eleven nearby.
That's exactly right, Justice Wentland. And again, going back to the long line of Supreme Court cases on similar issues, Atlantic Coastline Railroad versus Standard Oil. That was one where oil was delivered into Florida and there was no particular destination. Once it got there and it was stored, that was the end of the interstate trip. And then later when it was delivered to a later customer, that was not in interstate commerce. So again, that case, Higgins, Knight, and McCluskey are other cases. These are all cases from the Supreme Court recognizing that where there's a break in the chain of that interstate trip, that's a separate transaction, and the local component is not part of that larger interstate journey. So again, we don't have, yes.
I'm sorry. I don't know if this issue is raised before Judge Davis. I have a feeling it wasn't, but I'm going to ask you to respond to, well, if not section 1, then not section 2. So obviously section 1 is, we know from Circuit City, narrowly construed, and we know we're dealing with the residual clause of section 1. But then we get to the argument, well, if not section 1, then not section 2. Number 1, was that raised before Judge Davis? And number 2, what's your response to that argument?
Well, Your Honor, first, I think the argument was rejected in Circuit City, so it's a non-starter. The Supreme Court very clearly said that that being involved in commerce is very different from being engaged in interstate commerce. That was exactly the argument presented there. The Supreme Court rejected it, and courts time and time again have said you can't conflate the two, because that would render the section 1 exemption, it would just swallow the entire rule that the FAA applies to transactions involving commerce. So I think that's really a dead letter. And also, I do just want to say very briefly about the fact that this was not merely a pause. I know that plaintiffs have made that argument, that this was somehow the goods just paused at the local store. That's not what we have here. I don't think it's the right inquiry. Again, it arose under a different statute, the Robinson-Patman Act. But even looking at Gulf Oil and all of those cases involving that statute, we don't even have a pause here because we have two totally divorced transactions. But I want to just very briefly address the additional arguments that plaintiffs have raised. The Superior Court correctly rejected them, thoroughly considered them, and rejected them. There is no basis for holding that plaintiffs are not bound by arbitration here. They agreed to arbitrate. The agreements were reasonably communicated. They had reasonable notice, and under well-established case law, under Cowders versus Uber and Emanuel versus Handy from the First Circuit, it's very clear that this involves an agreement totally different from what was at issue in Cowders, where there was a browse wrap. This was very clearly communicated. The plaintiffs signed an agreement.
Is there anything to be said, though, when you're dealing with, waiving class actions and arbitration, that the document at least have to be read?
No, Your Honor, actually, no court has ever found that, and it's well established in the
Not as a matter of general contract. I'm just asking if there's any argument to be made, because here we're talking about Massachusetts law, and we've got a waiver of a class action, and I'm just asking along those lines, should this be a circumstance where the document needs to be read, or at least pulled up?
No, an opportunity to read it and notice that it's there and that you're agreeing to a legal document. An arbitration agreement is all that's required. And the First Circuit in Emanuel versus Handy dealt with this exact issue and said that there's no requirement that you prove that it was read. And here also, I just want to point out that there was an opportunity to opt out of the class waiver. So the class waiver was optional. But here you just look at this process and it's very clear. And also plaintiffs have raised this argument that somehow Grubhub waived its right to arbitrate. That argument is, there's no merit to that whatsoever. Waiver is for totally different circumstances where a party in litigation litigates and engages in litigation conduct that's inconsistent with arbitration. Here, Grubhub raised the arbitration agreement and moved to compel immediately. So
Counsel, is that the same as your argument that the plaintiffs waived their opt-out class action? Is you're using waiver in the same way in both?
No, Your Honor, it's a little bit different when we're dealing with arbitration. There's an established case law that says that a party waives the right to arbitrate through conduct in litigation that's inconsistent. Here, we have nothing like that. The provision that plaintiffs are pointing to regarding employee records, there's no private right of action. It's exclusively enforced by the Attorney General. There is a remedy, it's penalties, and the Attorney General here didn't even mention it in the amicus brief. So I think there's no argument to be made for that. And the Superior Court was correct. So we would ask, I see that my time.
I'm a little confused by your last point about, so they could opt out of the class, they could opt out of the class action in this contract. Is that what you're saying?
Yes, that's correct, Your Honor.
But at the same time, they don't have to read the contract to sign the contract. So how do they opt out of, it gets a little dicey whether there's really a chance to opt out of the class, isn't there?
Well,
any case is exactly like that. Because this looks like an easy Cowder's Emerald case in terms of they signed a contract. But when you start getting into the waiver provisions, then that's not really, is that covered by the First Circuit decision?
Yes.
In a case in which you could opt out of the waiver, where the contract allowed them to opt out, was that in a manual, or is it just a classic everything was waived case?
Well, Your Honor, I would argue that if you have the ability to opt out, it's even more favorable to the employee. So I would say our facts are even better in other cases, where you don't have that opportunity. But in a manual, again, that was a exactly similar situation to what we have here. And this case is nothing like the Cowder's case. There, if you recall, the facts were that when you simply signed up for an account by entering your payment information, you were deemed to have agreed to arbitrate. That's worlds away from what we have here. So here, there was very clearly an arbitration agreement, an opportunity to view it, and then an opportunity to download it again, and an electronic signature. So that manifestation of assent was very clear. And for all of those reasons, unless there are further questions, we would ask that the court affirm on those grounds, but reverse the Superior Court's decision on Section 1 of the FAA, which is a total outlier. So thank you.
Okay, thank you. Attorney LeBlanc.
Morning, Chief Justice. May it please the court. Grubhub's arbitration agreement is unenforceable for 3 reasons. First, Grubhub delivery drivers are undoubtedly transportation workers engaged in the flow of interstate commerce, which exempts them pursuant to Section 1 of the Federal Arbitration Act. Second, if this court finds that Grubhub
before you leave there, is there any case besides this one by the Superior Court where restaurant delivery drivers like this are found to be interstate transportation workers? Anywhere in the country that you can point us to a case that does the same thing?
Well, Your Honor, I think the predicate that, to answer your question directly, gig economy workers such as this, there has not been, other than this case, there has not been a case, but there's also not a case.
Well, that's clearly not true, because we know the Seventh Circuit case. We know Justice Tawani's decision here, and there are others, right? I mean, this is litigated around the country, right?
Correct, and I would say that
So just to confirm, we're the only case that's come out the other way. Is that right?
other than Waisaka and Rittman, which again, we can't
And
define.
Those are Amazon type
That's
cases.
last mile cases.
Yeah.
And Your Honor, I understand, and we would analogize, and I think the closest analogy for these particular delivery drivers are last mile drivers. And the reason why is because we're talking about, again, Circuit City defines Section 1's exemption. And the definition is transportation workers engaged in the flow of interstate commerce.
Not just transportation workers, but even putting aside that you have to look at the railroad workers and workers at sea and trying to define what transportation workers are. In the last mile cases, the product is going to who ordered it, and the driver is connected to that interstate travel. Here, the driver's not connected in any way to moving the goods across borders. The driver's connected to the goods, to the salt and pepper that got delivered to the restaurant, with the intention that that be the end of the delivery of the salt and pepper that went on the meal. I just don't see how you fit transportation workers in here, even if you put aside residual clause and Circuit City telling us to narrowly interpret this exemption.
Well, Your Honor, when we take a look at the Waisaka and the Rittman decisions, this is a situation where when you look at Amazon delivery drivers, essentially the products or the goods are being transported interstate by Amazon to arrive at their warehouse. In a situation such as Amazon, Amazon also hires independent contractors to pick up those products from the warehouse and deliver them as last mile drivers. That's the analogy to the case here. And that is referenced in both Rittman and Waisaka. And it says that these independent contractor drivers are just as likely to be treated as exempt as the Amazon drivers themselves. So in that situation, what we have here is we have goods, prepackaged goods coming from a distributor into a 7-Eleven or into a convenience store, into a gas station, a soda, paper towels, napkins. And the purpose behind 7-Eleven obtaining and receiving those goods is to sell them. 7-Eleven certainly doesn't want to drink a soda. So when their purpose is to sell the goods, they're selling the goods to the end consumer. And the whole purpose of 7-Eleven obtaining those goods is to sell them, which creates a situation where the flow of commerce, as defined by Circuit City, is not interrupted. The commerce goes from distributor to intermediary to end customer. And Grubhub cannot, because there is no law that overturns Walling, they cannot say that is not binding on this court. And in
So isn't there a difference between the last mile insofar as when 7-Eleven receives the goods, 7-Eleven is the entity that ordered the goods in interstate commerce. And at the time it receives the goods, or even at the time it orders the goods, it has no idea that the Wendland family is going to want some potato chips.
No, but the 7-Eleven or the convenience store does know that it has partnered with Grubhub to deliver those goods. This isn't a situation like the Lissy Cunningham or the other rideshare cases, because in those cases, and the court's made a big point of this, the airlines have not contracted or entered into any arrangement with Lyft or Uber or otherwise. But in this case, the convenience stores, the restaurants, all of the other stores that send these goods have partnered with Grubhub in particular. So they've made that decision, and 7-Eleven has made that decision to
Don't we focus on the primary responsibility of these drivers. We don't look at incidental. So they've got some treasured customers that they'll pick up at CVS for. That's not what that's sort of that's not their primary job. Their primary job is to go back and forth to the restaurants, right? It's not to do pharmacy pickups, right?
No, I would disagree with that, Your Honor. I would believe that the primary objective of these drivers is to deliver the products to their customers and obtain happy customers. If Grubhub wanted to stop their drivers from grabbing prescriptions or grabbing paper goods or grabbing other items, they could certainly do that. They could put in a policy. They could say,
no, but don't we focus on their core responsibility? I mean,
no, because
isn't that in the Seventh Circuit language, primary, and doesn't that appear in some of the other cases as well?
it is referenced in the Seventh Circuit case, Your Honor, but we are stuck with the statute that we have. And the statute has no de minimis requirement as to what constitutes being engaged in the flow of commerce.
The statute talks about interstate commerce workers, leads with seamen, then it goes to railroad workers, and then it goes to interstate transportation workers, which tends to give us a reflection of what they're talking about. And we gotta, you know, the first two terms define the third one, help define the third one, correct?
Well, yes, the first two terms do help define the third one. And there are cases, particularly the Birch case that we've cited in our memo, which was, it's a railroad case that came out right at the time that the FAA came out. And that case found even intrastate delivery on a railroad line is engaged in the flow of interstate commerce. There are other cases, Your Honor, from the Illinois Circuit, which looks at milk delivery or milk product delivery companies. And in that situation, milk was shipped interstate to a different state distributor. And then what the distributor did was they added chocolate to it. They made cottage cheese out of it. They made various other products. And then those deliveries were made intrastate only. And they were considered engaged in the flow of interstate commerce because there is no, there's no interruption of the intent behind where the product is going, much like the situation here with the convenience stores.
You know, this court's gotten it sort of head handed to it a number of times by the US Supreme Court on sort of interpreting the Arbitration Act too narrowly, right? I don't know if you've gone outside your area where we had sort of a series of them. Doesn't this invite the same type of, the Massachusetts court is kind of looking for ways of avoiding the Arbitration Act. And we've gotten sort of spanked for doing that. Mm-hmm.
Understood, Your Honor. And in this case, the alternative would be to look at the Cotter's decision, which was made in 2021, and to look at the language of the contract itself. And when we look at that agreement, we're not necessarily, we don't think the notice was appropriate, but we're focusing more on the assent that was offered by these workers. They were asked to sign an agreement with their execution being, by providing your electronic signature and clicking e-sign, you are acknowledging that you have read, understand, and or agree to be bound by the terms of any content or documents provided here within.
I thought that was interesting because it seems like they're making it perfectly clear that you've read it or you agree to it, meaning, you know, warning them to read it or otherwise you've agreed to it. Is that a fair reading of that or because it's not like Cowder's, which I'm unfortunately very familiar with, where you could skip the whole agreement process, right?
Well, but Your Honor, the local division 589 case, which was cited in our brief, indicates that the use of and or creates an ambiguity. And when we look at and if we read this document in the other way, you are acknowledging that you have read or understand or agree to be bound. And that, Your Honor, is the structure of the English language and the structure that Grubhub chose. And what we know,
But you just changed it. You just changed it.
Yeah, you just changed it.
Just changed it. Hold on.
Well, no,
It doesn't say that. Read, understand, and/or agree to be bound by the terms of any content or document provided therein. So if you take out the and, it says read, understand, or agree to be bound.
correct. And Your Honor, the grammatical construct of and/or, as cited in our brief, creates an ambiguity because it could be read as read and understand and be bound, or it could be read as read, understand, or agree. And Your Honor, again, that's why I referenced Cotter's. Cotter's requires a manifestation of explicit assent. And in this case, that's not here. What we're looking at is a document which gives these drivers an option. Yes, I read it, I understand it, but I don't agree to it. And the or word is what gets them out of that assent. So again, I would urge the court to look at the local division 589 case, as well as the other citations in our brief. And then, Your Honors, we also want to point out the Section 2 issue, which we have dealt with a little bit. The Circuit City Court, yes, they made a proclamation that Section 1 and Section 2 are not coterminous. However, the most recent decision, and it's the most recent decision relating to this very issue, is the New Prime case. New Prime versus Oliveira was decided in 2019, years after Circuit City. And in the New Prime case, the Supreme Court of the United States said that Section 1 and Section 2 must be read in relation to one another. This is not a situation where they need to be coterminous, but it is a situation where we need to look at the language and understand. Grubhub is making the claim that the drivers are not engaged in the flow of interstate commerce. Section 2 does not just say involving interstate commerce. Section 2 says the FAA only applies to contracts where the contract evidences a transaction involving commerce. Grubhub has taken the position in this case and in cases around the United States that these transactions do not implicate interstate commerce. And insofar as we want to have a broader definition of involving commerce than we do with engaging in commerce, we can do that, and we can still see that the related to the involving language and the New Prime's related language, we need to look at the entirety of the phrase, evidencing a transaction. And we don't have, based upon Grubhub's own arguments, we do not have any transactions that involve interstate commerce. In fact, how can Grubhub take the position? They disavow the notion that these drivers are in any way engaged in interstate commerce, and they have to disavow that all of these transactions are also not engaged in interstate commerce. And Your Honors, I do want to follow up on the one point that that was brought up at the beginning of the argument. The court has asked many questions about cases that are applicable outside of our state, whether or not our state's the outlier. The thing that has occurred here, Grubhub continually is focusing on 7th Circuit, 1st Circuit, 9th Circuit. The problem is Grubhub still cannot get past the Walling decision relied upon by the lower court. The Walling decision made a finding that the engaging in interstate commerce language was very clear. And it made the finding that until any goods get to their final destination, their final customer, they are still in the flow of interstate commerce. We can look at all of these other cases. None of them are binding on this court in the way that Walling is. Likewise, we look at the Wysocka and the Rittman decisions. And again, we would analogize these to last mile Amazon drivers, particularly in light of the fact that this is a very, very similar situation. Amazon has partnered with independent contractor drivers, just like Grubhub has contracted with with other contractors or vendors to sell the goods, and they end up in the hands of the end user customer. Unless there's any questions, I would rest and ask that the court uphold the lower court's decision.